Hey everyone, happy Red Friday and happy New Year. A lot of people don't realize this, but medical cannabis in Canada did not become legal because the government wanted it to. It became legal because patients challenged the government in court and they won. This is especially important for veterans and patients living with chronic pain, PTSD, or long-term health conditions. Medical cannabis in Canada isn't just a policy decision. It is protected by constitutional law. Before medical cannabis was legal, patients who relied on it for seizures, pain, trauma, or anxiety were being criminalized, even when it was clearly helping them. So patients started taking the government to court. In the year 2000, a case called R versus Parker changed everything. Terry Parker was an epilepsy patient who depended on cannabis to control seizures. The Ontario court ruled that banning his access violated Charter 7 of the Canadian Charter of Rights and Freedoms, the right to life, liberty, and security of the person. Because of that ruling, the federal government was forced to create Canada's first medical cannabis program in 2001. But the early system was very restrictive, and again in 2003, patients challenged it in a case called Hitzig versus Canada. The court ruled that the program didn't provide reasonable access and ordered the government to fix it. Once again, patients won. Then in 2015, the Supreme Court of Canada ruled on R versus Smith. The court said patients could not be limited to dried cannabis only. They ruled that oils, extracts, and other non-smoked forms are legitimate medical options. This decision clearly recognized cannabis as a medicine, not just a controlled substance. In 2016, another major case called Allard versus Canada was decided. Patients challenged the ban on growing their own medical cannabis. The federal court ruled that patients have the right to reasonable access, including personal or designated growing. Once again, the government lost. So medical cannabis in Canada exists today for one simple reason. The government kept losing court cases. Judges constantly ruled that denying patients access to a medicine that reduces suffering is unconstitutional. For veterans, this is incredibly important. The courts have recognized that medical cannabis can play a role in treating chronic pain, sleep disturbances, PTSD, and nervous system dysregulation. Using medical cannabis is not abusing the system. It is not a loophole, and it is not something you need to justify or feel guilty about. Medical cannabis in Canada was built on patients' rights, compassion, and the Charter. Understanding this history helps remove fear, stigma, and confusion around using it as part of your healing journey. You're not doing anything wrong. You're using a right that patients and veterans help secure through the courts. Thanks for watching, everybody. Hopefully you learned a little something, and I hope you enjoy your weekend. Cheers.